afternoon to you all. Um, this is the legal segment of our CAM meeting 2023. And today we'll be discussing the very important subject of the rights of the child as enshrined under the laws of Ghana. And we will be explaining what rights our children have, what care and protection mechanism the law has put in place for children, and how we can better secure the welfare of our children. And with me to do justice to the subject is our very own lawyer, Bennett Anim. So, Counsel, you are welcome. All right, so we will start off with asking, who is a child? I mean, we always say children, child. Who is a child? Legally speaking, who is a child?
Well, a child has been defined in our laws to be any person who is below the age of 18 years. But other provisions of our law, and depending on the circumstances, has limited some of the age requirements. So, for example, depending on what is happening, a child could be somebody under 12 years, a child could be somebody under 16, under 18, or under 21. But generally, and for the purpose of our discussion, and even the provisions of our constitution, a child is any person who is below the age of 18 years.
Thank you very much for this explanation. I think it's very clear. Any person who is below 18 years is considered a child. So, lawyer, can you tell us what are some of the rights of a child? I mean, I know that as human beings, we all have some inherent rights. But why do we zero in on a child and set out special rights for children? Can you help us with this?
Well, first of all, let me say, we place emphasis on children because, like we know, children are vulnerable. I mean, they cannot do for themselves what adults will do for themselves. If a child sees a fire set up here, until the child enters the fire and gets burnt or gets hurt, the child will not realize that that thing which he is entering is fire. So children are vulnerable. So in the wisdom of our leaders, they made provisions in our constitution that when Parliament sits, they should make special provisions concerning the rights of a child. And let me state at the outset here that the rights of a child are also responsibilities of other people, being it the parent or the guardian or any other person reasonably expected to hold such obligation. So the rights of a child, the child of himself may not be able to enforce his own rights. So the obligation is on the parents or any other person having custody or reasonably expected to hold that obligation to respect or observe the rights of the child.
Okay. Before we delve into the specific rights of the children, so fundamentally it is because children are vulnerable. That is why there is a special provision dealing with their rights. But you made a very interesting point that the rights of a child inversely means that there is an obligation on an adult to discharge in respect of that child. Why is there an obligation on an adult? Because, well, if you have your rights, go ahead and assert your rights. Why would the law place an obligation on adults towards the children? Can you help us with this?
Okay. Let me give a brief explanation here. Let me use some one of the children's rights to explain. A child's right to, for example, education. This morning when I was taking my child, when I was dropping the guy at the school, when we got to the entrance, the guy, he said he was going to come back with me. He wouldn't go to school. But the child has a right to be educated. But he does not know the importance of those elements. So it is my obligation as a parent to ensure that the child is educated. If I say that, I was taking the child to school, he said he wouldn't go. So I did my part, but he said he wouldn't go. The child, being a child, has not the capacity to determine the relevance of that which is being administered unto him, that which we are calling rights. It is in respect of this that the obligation is on the parent or the guardian or any other person having custody of the child who is of age and appreciates the relevance or importance of these rights to ensure that they are respected or observed.
Thank you very much for this wonderful explanation. So we will delve into looking at some of the rights that the law has enshrined in respect of children. I think the first right you've already mentioned, the right to education. Can you throw more light on that subject? Right to education, does it necessarily mean that if the parent or the adult doesn't have the resources to be able to take care of the child should lose his or her education? How do you explain that to us?
The laws of Ghana, and specifically the Children's Act, is that which has made these provisions and stated that every child, as has been defined, has a right to education. And in addition to that, the law has also gone ahead to define a responsibility of a parent. And included in those responsibilities of a parent is to educate the child. Unfortunately, the Act did not state that if you're a parent and you have money, take your child to school. If you're a parent and you do not have money, let your child sit at home. The obligation is on the parent to make provisions necessary for the child to attend school. Of course, the strength or your ability or financial ability may only determine the type of school that your child will go. But ultimately, as a parent, you have an obligation to ensure that your child your child is educated or developed in the manner that ensures the well-being, welfare, development of the child.
Thank you very much. I also wanted to find out, does the state have any obligation towards the realization of this right to education?
Certainly. The state you would imagine has made several provisions or avenues necessary for the education of the child. So as a parent, you will not build your own school. as a parent, you may not employ your own teacher to teach your child. It is the government that has made provisions, defined curriculum, set up institutions, employ teachers, build buildings, etc., necessary for the child to be developed. The only obligation which are provided for by law is that you as a parent send a child to school. Send a child to school. And sending the child to school, you also may have some obligation. At home, you may have to provide the school uniform, etc., for the child. But the place where the child is going to learn, you are not the one who provided for it. It is the government who has put this in place for the development of the child.
Okay. I think we would have to move to the next one. The Children Act also provides for the rights of a child to a name and nationality. To a name and nationality. And practically, there are several instances where you find out that some men, are unable or unwilling to name a child because, well, they may have some issues with the identity of the child. How best can this right to a name be realized under our laws?
Thank you. The law, as you said, has provided every child has a right to name. And the law has stated that it does not matter whether you, the parent, the father, mother, you are living together, whether you are married or not, at the time of the birth of the child. The rights of the child is to a name. And the person, as we have come to know, who has a duty to name the child is usually the father of the child. But most of the time, you would realize that due to misunderstanding between the mother and the father, the naming of the child even becomes an issue. And we will not allow you to name the child until you do ABCD. The law has not said that until anyone does ABCD, the child must not be named. The child has to be named regardless. And it is the obligation of, usually, the father to suggest a name for the child. So when anybody, being the mother or the grandmother or any other person who has purportedly been a managing director over the child and wants to prevent the naming of the child, the law has provided avenues that anybody being affected by that can explore to ensure that the child has a name.
Well, thank you very much for the answer. There's this very common issue of child marriages. I understand that under our laws, a child or any person of 16 years can consent to sexual activity. So if the law allows a person who is 16 years to have sexual intercourse, is there any justification why the law would prevent somebody, let's say, who is 17 years from entering into marriage? Is there any justification for this provision?
Yes, there is enough basis for such provision. Marriage in itself is an institution. It is not a casual sexual intercourse by a man and a woman, where after the event, both of them part ways. The institution of marriage ensures that after the ceremony, the two of them are living together, the two of them have rights, the two of them have obligations. The two of them are expected to live together as man and wife. The law recognizes that anybody at the age of 18 and above is an adult. And even for the purposes of marriage, when you are 18 years and you agree or consent to enter into marriage, and you are not at the age of 21 years, the law still requires that even your parents must give consent before you can enter into that marriage. So you may be 18 years, all right, but because you have not attained the age of 21 years, when you want to enter into marriage, you will be required to obtain the consent of your parents. But let me come back to the child. Under our laws, nobody is allowed to force a child into marriage. And there are other elements to call betrothal. Nobody shall force a child to be betrothed. So that, for example, you would have an arrangement, a parent will have an arrangement with another person to give the hand of the child, or to give the child in marriage, or that to give the child to that person to be married when the child attains the age of 18 or 21. That arrangement is unlawful in Ghana. So no child, when you are at the age of 18, of course you can get married. But the law says that you cannot be forced. The marriage must be voluntary. And the other person coming in must also voluntarily request the hand of your child in marriage. And the child must willingly accept. The child must not be forced. So it is, in fact, it is an offense. All these rights that we are discussing, anybody who flouts them has flouted the law. And the law has made provisions or has set sanctions. In fact, you can go to jail for 1 year for flouting any of the rights that have been provided for under law. Indeed, even the right to education, which we just mentioned, if you fail to observe the right, your child's right to education, you can go to jail for 1 year.
Very interesting perspective on this subject. Our next point is one concerning issue, especially with family business. Say, for instance, I am a cocoa farmer. I have large tracts of cocoa and other cash crops. During vacation, I invite my children to assist me in my farming activities, carrying cocoa, cutting the pods, and all of these other ancillary issues. There's this hula baloo about, we should not allow our children to assist or to even help us in our work or in our farms because it is against the law. Can you throw light on this situation for us? Is this just the case that we cannot help our kids? Because I know that growing up, we used to follow our parents, we learn their trade, and that is what we are using now. So if I should invite my child to help me in the farm or whatever business I'm engaged in, how is that against the right of a child? I mean, rather helping a child to acquire skills. Can you explain this thing to us?
Thank you, Justice. The law, like I have always said, has made special provision. The Children's Act is a special provision or law concerning children. Helping your parents at home or farm may not necessarily be unlawful. Indeed, it may be part of the child's training. It may be part of the child's training even at home. But the law is quite clear on what can be done and what cannot be done. For example, the law allows you to get your child or allow your child to do what we call light work. And let me state here that if you are not 15 years, for example, you cannot be engaged in any form of employment. If you are not 15 years, you cannot be engaged in any form of employment. But the law allows you to engage a child in what we call light work when the child is 13 years and above. So if the child is under 13 years...
Lawyer, what is light work?
Yes.
Light, is it about the lights we see or sound? I mean, can you explain what light work means for us?
The work is light if it does not expose the child to danger. If it does not affect the attendance of school of the child. If the child's school attendance is not affected by that work, then the work is light. If the child is not exposed to moral hazards, then the work is light. If the child is not exposed to carriage of loads, portrait, carrying things, carrying heavy loads and be selling. If the child is under 13 years, these are not light works, then the child cannot be exposed to. If the child is, for example, also below 18 years, the child cannot be allowed to engage in certain types of work. For example, going to the sea. So yes, you want to go to the sea, catch some fish for the family, but that one you cannot go with the child because it is considered hazardous. It is not considered a light work. If you are going to do your galamsey, or you have some loads of cocoa in the farm you want to go and carry, your child who is less than 30, these works are not light work. So your child cannot accompany you to either go to fishing or to go and assist you in your galamsey work, or to go and carry your bags of cocoa from the farm. These are not light work.
So let's look at this other controversial situation. So I, as the parent, I may be holding some religious belief. Say, for instance, one of the beliefs may be that we do not accept blood transfusion. That has always been our belief. In fact, the law recognizes our right to a religious belief, which the law protects. There is a situation where the child is sick and the child is taken to the hospital, and the doctors say that, well, there has to be a blood transfusion. Can the parent rightfully say that because of our religious belief, the child should not be administered a blood transfusion? If that is the case, would that affect the rights of the child? Because we all belong to the same religious faith.
Thank you. Attached to the child's right to education is what we call well-being of the child. The child has a right to well-being, and it starts right from birth. We know that when children are born, they are given what we call immunization, etc. And as a child, the child may contract certain diseases and they may require certain type of treatment for the child. If you are an adult, you have a right to, in fact, even say you want to go to the hospital or not, you want to sit at home. But as a child, the child has not the capacity to determine whether I want to go to hospital or I want to do this. So every child has a right to well-being. So no parent under our laws has a right or can deprive a child from being immunized. Oh, I don't want to because of my religion, or in our home, in our family, we don't immunize our children. What is polio? In fact, in our family, we don't do immunization. We don't immunization against measles, etc. It is against the law. In fact, any parent found to be depriving the child to immunization can go to jail. I've already stated that. In fact, you can also, under the pretext or pretense of religion, say you want to refuse your child blood transfusion. Blood transfusion is part of medical treatment. So you cannot, under no circumstances, it's part of our laws, under no circumstances would any parent or guardian or any other person having custody of the child say that because of a religion or religion of the child or whatever, I will not allow the child to have this blood transfusion or to be subjected to this kind of treatment. No parent, no guardian, or no person having custody of a child has the right to do that, and it is unlawful. In fact, it's a criminal offense, and anybody found to have done that is liable to the law.
Thank you very much. Ebusia for samati. Enti se obayare a na odine ko hospital on timi ko kase ye manu muja ompene o ya kra emra no ebo ne ho ban. The next important question I would want to ask has to do with making decisions in the family. You know, within our African context, usually is adults that make decisions for family. The views of our children are not really recognized. As a child who is dependent on my parents are the ones who take care of me, provide shelter, food, clothing for me. Do I have any right to express an opinion when there is a matter that affects the family and myself as well?
Thank you. Earlier, I said that this morning when I was taking my child to school, the child said he wouldn't go. He wants to come home with me. That's his opinion. He wants to come home with me. The law makes provision for us to respect the opinion of our children or of the child. So, depending on the age of the child, the opinion of that child has to be taken or sought in any matter that affects him or that affects he or she, the child. So, my child who is 4 years old, whenever you ask him what he will eat, I'll drink tea, morning tea, afternoon tea, evening tea. That's his opinion. But is that opinion good for the child? No. Is that opinion good for the child? No. But if a child who is 10, 11, 12, up to 18 years, and is capable of expressing opinions on matters that affect him, his education, his school, his education, what he will eat, etc. The law requires that. In fact, the law mandates us to seek the opinion of the child. And that opinion must be given enough weight. Not that when the child starts to talk, oh, stop, how old are you? No. The opinion of the child must be obtained. And in arriving at the final decision of that matter, the opinion of the child, as was expressed by he or she, by him or her, must be taken into consideration. Oh, Kwajo said this. Kwajo is a child, but this thing that he said, we think it is very reasonable. I think we can consider it. So the child has a right of opinion, and that must be respected. Let me add again that these rights that we are stressing, any one of them that we fail to consider is an offense. So if you are taking decisions that will affect the child, and you fail to consider the opinions that may have been expressed by the child, you fail to consider that and arrive at your own conclusion without considering that you may be guilty of an offense against the child's rights.
This is very, very interesting education on the subject. The good book says that spare the rod, spoil the child. And you have also stated that it is the duty of every parent, guardian, or an adult to raise up the child in a way that his welfare is protected. Here we are, for instance, I have a child who is a deviant. Am I entitled to use cane to put him right? Because the good book says that spare the rod, you spoil the child. How does the law view this situation?
Thank you. The law does not prevent us from correcting our children from deviant behaviors or wrongs generally. The law only tells us that we should not subject the child to inhumane treatment for whatever done. I mean,
would for instance, slapping the child, hitting the child with a cane, at least about 5 strokes? What is the standard?
Yes. So I'm coming to that. The law says that we should not subject the child to inhumane or cruel treatment. Yes, you may have a cane at home to correct your child for any wrong done or for being deviant. But the level the level of correction, the exertion of force that you use to correct the child will determine whether that treatment of the child is cruel or not. So, for example, you said your child has, let's say your child has taken your 1 CD to go and buy whistle, toffee, whatever, and he didn't mention it to you. When the child came, where is the 1 CD? That day I took it. I used it to buy toffee. Hey, you didn't ask me before taking my 1 CD. Meaning you were a thief. And then you cane the child to the extent that the skin and other parts of its body are all in a manner that can be described as cruel. This kind of treatment cannot be visited on any child. In our laws, when you are correcting a child, the law requires that the treatment or the correction that you are giving to the child, depending on his age, should be capable of understanding the correction that you are giving him. So if you have a 2-year-old, 3-year-old, you bought blade to trim your fingernails, you did it, and then you left the blade. The child who saw you trimming your fingernails, and then when you left, the child unattended to, which in itself is an offense. When you left the child 3-year-old unattended to, which in itself is an offense, the child picked the blade and also, began to cut. This time, the child didn't cut his fingernails. The child cut a full hand, though the hand did not cut off. And then as a parent, you came, you saw blood all over. Then you start hitting, slapping the 3-year-old. You pick a cane, beating, caning the 3-year-old. And the 3-year-old will be crying. The question is the 3-year-old capable of understanding why you are beating him or her? If the answer is yes, then you may be justified, depending on the extent of beating. If the 3-year-old is not capable of understanding why you are even beating him or her, then you are not justified. Then you have trampled upon the rights of the child. So yes, you can correct a child, but depending on the age and the level of correction that you administer, it may be described as reasonable, unreasonable, or cruel visited on the child.
Thank you very much. I think from your exposition, it appears that the law has been designed in such a way that the main consideration is to look at the welfare of the child. The welfare of the child. Can you explain to us what this thing means about the welfare of the child? Anywhere you go and there are issues concerning the child, you hear welfare of the child. Welfare, is it about money? What does it mean in the context of the rights of a child?
Thank you, Justice. You have put it right. The law has stated that anything that affects a child, any matter that affects the child that is being considered, the primary consideration, the only consideration, the only legal consideration that we look at is the welfare of the child. The welfare of the child has been defined to mean that which is in the best interest of the child. So anything at all, not in the best interest of the child, cannot be vested on the child. So, for example, recently in court, some couple, as a result of misunderstanding, went for divorce. They divorced, but there are two children. believe now we know children, anybody under 18 years. There are 2 children of the marriage. And as part of the marriage dissolution elements, there were properties that they had to share. And the courts had said that the property that they were living in, or they are living in, which is the marital property or their matrimonial home. The matrimonial home was built by the 2 of them, so it belongs to the mother, the father, or the former husbands and wives. The High Court said that now that you are separated and you are saying the property belongs to the 2 of you, I am making an order that you go and sell the property, then you share the money, so that you go and use the money to do whatever you want to do. And then the woman said, in any case, the court also said that the children, the woman had asked for it. The children should be given to the woman. But the woman said, I want to keep the children. And the woman said, no, I don't think the court considered the best interest of the children before it took that decision, or before it made that order. So the woman went to appeal against the decision of the High Court. And what did the High Court say? The High Court said, no. We don't agree. What did the Court of Appeal say? The Court of Appeal said, we don't agree with the High Court. We believe that if the Court of Appeal, the High Court, had considered the best interest of the child or the children, it would not have come to the conclusion that the marital home should be sold and the money shared. Why? Because the court, the man had already said that, oh, me, the man, when my father died, he gave me a lot of properties. So me, when we sell this, I have a place to live. But the woman has not said anything like that. So when the property is sold, the woman will now have to go onto the streets and look for a new property to rent. Not for the man, because he already has others. So the court should have considered that, where are these children going to live? Are they also going to go to the street until the mother finds a new place before the children can find a place to live? So no, we will order that what the High Court said is wrong. We will cancel it. We will make an order in place of that order that the marital property, the matrimonial home, should be given to the woman together with the children, so that the other properties will be for the man and the marital home. So the Court of Appeal considered what we call the best interest of the child, which is the welfare principle, which is enshrined in our jurisprudence.
Thank you very much. So essentially, you are emphasizing the point that children have a right to parental property. So the property that is acquired by the parents are not to the exclusion of the children. The children also have an interest. So lawyer, so if I observe that a child's right is being abused or violated, what can I do? Where am I supposed to go so that the child can be protected?
Okay. Let me quickly add, because you mentioned the parental property, let me quickly add this right to parental property of the child. That if I'm a parent, or no child can be deprived of a reasonable portion of the parent's estate. Now, for most people who are in employment, you realize that their pension contribution, Social Security, SNET, the law requires you to make nominations that your spouse or any other person that when you are not there, your contribution should go to. Right? At the time that a lot of people will be entering employment, there will be no marriage or no child. So they will dominate other persons, my brother, my mother, etc. But when later they get married and begin to give children, they don't go to make changes to these nominations. So at the time of death, you would find that the nominations are in other person's name. But the law says that the child has a right to property, parental property. So under our Pensions Act, when you are a child, anybody under 18, and your father or mother fails to make you or nominate you as the beneficiary of his pension, you are automatically a nominee. So if my father nominates other persons, those other persons may be there. The law says that 60% of the whole that which will go to the beneficiaries will come to me, the child, and 40% will go to whoever was nominated.
Thank you very much. So can you tell us, how can we vindicate the rights of the of the child?
Thank you. The law has set up institutions necessary for the adjudication or vindication of rights of the child. In any case, first and foremost, if I find that the rights of a child is being trampled upon, now because flouting the rights of the child is a criminal offense, I can make a complaint first to the police station. Any nearby police station, that complaint can be made. Why? Because that which I have seen being done is a criminal offense. 2, the law has set up a social welfare department. This social welfare department deals also, in addition to other things, matters affecting children. So if I find that a child is being maltreated, or a child is in need of care, or a child is not being protected, I have a right to go and make a complaint at the social welfare department. In fact, the social welfare department has obligation to also make inquiries concerning the complaint I have made, just to ensure that the welfare of the child is being reflected, or the welfare of the child is not being trampled upon. The law has also set up even courts. We have a family court or family tribunal that when matters affecting a child comes up, that is a forum for adjudication. In fact, it is also a court capable of adjudicating all other matters. But this is a special court the state has put in place to adjudicate matters concerning a child, being it custody, want to have access to the child, there's no maintenance, money must be provided for the care of the child. These are courts this is a court that the state has set up to adjudicate matters concerning the child.
Thank you very much, lawyer, for the education. You have been enlightened about the rights of the child. We went through what we call the welfare principle. We also espoused on some of the rights of the child, the right to education, the right to good health, the right of opinion, protection from exploitative labor, protection from arranged marriage, and other matters. Let's accept and know that our children are vulnerable. The law has designed a careful, special mechanism to protecting their rights. Protect the rights of the child, let's respect their rights, and most importantly for parents and adults, let's discharge our obligations towards our kids and those in our communities. Thank you for listening, and God bless you. Thank you, Councillor.
Hello, Pathfinders. It's the dream Pathfinder Camporee. So, Pathfinders, are you ready for this year's Dream Pathfinder Camporee?
The West Central Africa Division welcome you to the Dream Pathfinder Camporee.
I'm so excited to be meeting other Pathfinders from the 22 countries from the West Central African Division.
Let's meet on 24th to 30th December 2023 at Valley View University Campus, Accra, Ghana. Pathfinders.
Hello, Pathfinders.
It's the dream Pathfinder Camporee.
So, Pathfinders,